Hi, I'm Greg Dell here with attorney Stephen Jessup. And Steve, we have the opportunity to talk about a recent case that came out of the Middle District of Tennessee, not handled by our law firm, but a typical individual disability lawsuit dealing with Unum on the classic residual versus total disability issue, mostly that we see with doctors because of their procedures. So let's get into a little bit of the facts of this case. It's only a summary judgment motion, which you'll talk about the legal merits of what that is, explain to our viewers for that. And also the significance of how this is really this is a good ruling for medical professionals because it's something we deal with on a daily basis.
Yeah, this is a case that revolves an OB-GYN. And unlike, say, for instance, orthopedic surgeons, general surgeons, ER surgeons, there's a mixture of billing and procedures done. You're not always in surgery. Sometimes you just have general office hours, things like that. That's very common with a lot of doctors. So in this particular case, the Dr. Nylander in it, she's working as an OB-GYN. She was in the process of a surgical procedure, and there was an accident during the procedure that resulted in her severing the tendon of her right index finger, which is her dominant hand. She ended up having treatment to repair, get back to work. Her doctor cleared her return to work. She was then later in this operating room performing a procedure, and she noticed an issue with her right hand and being able to clamp properly and be able to do it, which caused her concern. And a lot of times when it comes to doctors, especially surgeons, there's always this overriding idea of patient safety. And when it becomes an issue and a concern that something that may be physically wrong with you could adversely affect the patient, that's when a lot of doctors think maybe it's time for me to step back, take a break, maybe think if I need to even stop performing surgery. Dr. Nylander in this case took that option. She filed a claim with Unum. During the claims review process, Unum ultimately denied the claim following an independent medical evaluation, and then a lawsuit was followed. And like you said, this ruling that came out, this isn't a decision on the actual case. This is a ruling by the judge in which is known for a motion for summary judgment.
And let me just back you up 1 second. So Unum did a medical evaluation of this claim. Did they actually have her examined?
Yes, yeah, there was an independent medical evaluation. And that IME doctor arguably said, listen, I don't see anything objectively that would prevent her from performing her duties from a surgical perspective. That would become one of the probably two biggest takeaways in the decision that the court ruled when making a decision on the motion.
So this is always the interesting dynamic with any physician, dentist, doctors, any of the that medical profession that we represent is here you have a claimant, a doctor, OB-GYN delivering babies, doing all kinds of surgeries on women saying, I don't feel safe doing these procedures where somebody could get hurt, a child could die, the claimant could die. I just don't feel comfortable. I can't effectively do them. Another doctor looks at her for 20 minutes, 30 minutes and says, you should be able to do them. Which one is it? This is what we deal with in every case, regardless of what the medical condition is.
And I think one thing that it was helpful, especially once it gets into court, is this was an individual disability product. It was originally a Paul Revere policy. That's all now through Unum.
Right.
So during the course of that, this isn't a situation, these group policies, where there's a favorable standard of review for the insurance company. So a lot of extra information. There was even depositions taken in this case of Unum's professionals. And that argument from Unum, we relied on our doctor who said there's nothing objectively that we can see that would prevent her from working, as opposed to what the court said when it came to the doctor is her subjective understanding. The court reasoned, here's a doctor who's been doing these type of surgeries for years. This is what she does, she knows. And her subjective ability to know her body and know if there's an issue in the surgery, that speaks volumes. There was no evidence of malingering or any other, second gains argument that would attack her credibility, if you will. So the court really determined in who is the court's going to believe more to determine if this case is going to continue to be able to go forward. Unum's doctor or the actual, claimant. Here they sided with the claimant and said, we will give the credit to you. And not only that, Unum, we're looking through this policy and there's nothing that has this objective medical evidence requirement. So the court even said, you are creating a new standard that isn't contained in the policy that an insured has to be able to meet. Now, some of these nuances become very important because, like we said, it's a motion for summary judgment. This isn't trial. There isn't a winner as to who's going to be totally disabled, residually disabled, all that. A motion for summary judgment in a situation like this is Unum's attorneys filing it with the court and saying, listen, there's no actual argument here. There's no legal issue to be determined, so we want the case dismissed now. Because Unum wants to argue this is residual disability. This isn't a total disability claim. So the court is trying to determine, is there a genuine issue of material fact to allow the case to go forward as a total disability claim for later a jury to make a determination on that. So that's still to be seen what will happen there. But when the judge is taking a look at who do I believe, and when I look at other case law going on, is there enough information to support what the claimant here, Dr. Nylander, is telling me, or is Unum correct in their assessment? Here, the court decided to go with Dr. Nylander, saying that, listen, her subjective understanding of what it takes to do these surgeries and the problems that she has with her overriding concern of this idea of patient safety is certainly an issue for a jury to make a determination on. There's an issue of material fact. So that in and of itself is great because a lot of doctors are faced with that. And not really going into, in this opinion, but also something for consideration. If you're a surgeon and you have a medical condition that could be affecting your ability to perform surgery, not only are you at risk of injuring your patient, maybe something happened to you based on the injury, you also got to think of concerns with malpractice.
Yeah, well, that's number one.
Every
doctor's
and a lot of doctors are thinking about that.
So Unum had a two-part strategy in this claim. Number one is to say you're not disabled, therefore whatever else you're doing is irrelevant. You're not disabled, you should be able to do everything. And in litigation, their first strategy was, we don't even want a jury to consider this. We're going to try to knock you out before you even get to the jury. Judge says no, too many facts in dispute, it's going to go to the jury. The second issue that Unum was trying to cut the legs out from this doctor was to say, look, you're seeking total disability benefits. However, look, we know you're an OB-GYN, we know you did surgery, but your surgical codes were only showing about maybe, say, 15-20% of the amount of work you were doing. The rest was your office code. So you're telling us you can't do surgery, but what about getting in the office for 70-80% of the time? And so how did the court evaluate that so that her total disability claim would stay alive and make it to the jury?
Well, what Unum was arguing was that, you have to be unable to do the material and substantial duties. So when they were looking at leading up to her injury, those percentages of time, like you said, it was 15-20% of her actual time in billing, actually less of the billing, 5 to 9% of the billing codes were related to surgery. So Unum's position was, this isn't a material and substantial duty of your job. It takes up such a small amount of time and a small amount of your billing. So because we believe you can do some of the material and substantial duties, you're not totally disabled. The court did its evaluation, heard arguments obviously from Dr. Nylander's attorneys, Unum's attorneys on it, and basically taking other case laws already in existence, made an argument that time in and of itself is not indicative of material and substantial duty. They said there are some professions and occupations, doctors, dentists especially, where a small percentage of what you actually do time-wise could generate the majority of your revenue. And therefore, revenue plays just as big a role in what constitutes material and substantial duty. Obviously, the doctor is going to make a lot more in the way of revenue from doing surgery than doing, administrative office work that's going to be billed for. So the court shot that down, Unum's argument down, and said, no, there's enough information here to show that even though it wasn't the majority of her time or billing done, it was a majority of her revenue, and therefore it is material and substantial.
Yeah, and these policies don't have a clear line to say, well, if 50% of your revenue comes from those particular duties that you can't do, then we consider that to be substantial material. And if it's less than 50%, then we don't consider it to be substantial material, and maybe you're partially disabled. Now, there are other carriers who have started to write policies like this, talking about what percentage of your revenue is coming from
you
which
see that
particular,
with the legal profession especially.
Yeah, which particular duty. So this has always been the dispute we have on these individual disability claims, whether it's Unum or any of the other carriers that sell these policies. And obviously we've represented tons of OB-GYNs who face this issue, because not only is it the OR, but what about all the work incidental in the office?
To get you to the OR.
And what about if you are a surgeon? Take ENTs, for example, who do a lot of surgery outside. Tons of professions orthopedic doctors, they spend 3 days a week in the office and 2 days a week in the OR. Does that mean because you can still do your office practice but you can't do the OR that you're not totally disabled? Even the general surgeons have to be in the office to meet with the patients incidental to surgery. So Unum knows this. They try to bully just about every single client with this same type of argument. Well, you're not really total because you're still in the office. And even though you're not doing surgery, we think you're residual. And it makes significant impacts on the value of the claim, often because it can jeopardize a lifetime benefit. It can be a significant difference in the amount of benefits. And look, Unum's goal is to pay as little as they absolutely have to on a claim, plain and simple. They're in business to collect premiums, and they really don't want to pay out claims. That's just the way it goes. So this is a great case in terms of, again, reminding Unum to say you're not going to be able to bully everyone every time with these types of claims. We have seen some opinions that may have gone the other way, but every fact pattern is different. But there's a lot more in favor of, if you're a surgeon, you can't do surgery, there's a high likelihood that you'll be able to be found total. Now, end of the day for this claim, it's going to go to trial. We don't know what's going to happen, but it's really going to all come down to the credibility of this doctor. And since a lot of it is subjective, whether she can or can't do these procedures, Unum's going to throw the kitchen sink at her from everything that has anything to do with her medical, from video surveillance to credit applications she's filed to privilege logs to people she knows, people she worked with. They're just going to really try to throw the book at her and look up every single thing about her social media profiles to try to say, is she telling the truth about other things, not just surgery? And if she's not telling the truth about these other things, then maybe she's not telling the truth about her ability to do the work that she says she can't do. So we'll see how this plays out. Obviously, you and I know there's a high likelihood this won't make it to a jury. It will be settled, most likely. We wish the claimant the best. Typical case that we handle all the time. If you have a case with Unum or any other disability carrier, feel free to call any of our disability lawyers for a free consultation. We handle these cases all over the country. We'll let you know right away whether or not we can assist you.